Hi, may I see Corey Williams, please? It's a reset from this morning. State, I don't recall why we reset this, do you?
I believe the public defender did.
Okay.
But
Mr. Miller, did you have a chance to review the affidavit in this case?
I did, Judge.
Okay. Sir, you're charged with lewd and lascivious molestation of a victim under 12. State, is this a first-degree punishment by life felony?
Your Honor, it is, and just to advise the court, Your Honor, Detective Innocent Doles of the Fort Lauderdale Police Department is also present, and I believe there is information she can provide the court that will satisfy the burden of proof evident or presumption granted.
Okay. Ma'am, will you raise your right hand for me? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down. Tell me your name.
Lorette Innocent Doles,
And where are you employed, ma'am?
Fort Lauderdale Police Department.
You're a detective there?
Correct.
Okay, thank you, ma'am, for coming to court. State?
Yes, just a couple issues. First, Detective, you took from the alleged victim, correct?
Yes.
And how old?
We're going to use initials for the alleged victim.
Correct.
Okay, thanks.
And approximately how old is she?
11 years old.
Okay. And did you qualify her before you
Yes.
took her statement? And could you just advise the court how you qualified?
I asked the victim to differentiate between the truth and the lie, and she was able to do that, and I also swore her in.
Okay, all right.
Okay.
Now, how old is this alleged victim, ma'am?
11 years old.
Okay, got it.
Okay, and you also took a statement from the defendant, correct?
Correct.
And just so the court understands, this probable cause affidavit, was it written before or after you took the statement from the defendant?
Before.
Okay. And what information did you obtain from the defendant when you took his statement?
The defendant admitted to touching the 11-year-old victim.
Okay.
Do you recall where he admitted touching her?
He couldn't recall. He recalled going into the room and touching the victim.
Okay.
Let me ask you, just be more specific when you say going into the room. Whose room?
The victim's room.
Okay, bedroom?
Correct.
Okay, and what time of day or night would he have gone in there? Do you know?
She's not sure. He's not sure. It's
Like,
nighttime, early mornings.
Was it after she had gone to sleep? Or?
Correct.
Okay. And do you know whether or not he normally stays in that bedroom?
No, he doesn't.
No, he doesn't. I see here that was he a family member or just a guest?
He was a friend.
A friend, okay. And all right. Did Mr. Miller, is there anything if you have a question to, I'll allow you to ask it at this time.
I'll be brief, Judge. How did you say that the family knew Mr. Williams?
The victim's mother grew up with the defendant.
They grew up together? Okay.
Yeah. They knew
Nothing
each other.
Okay. And all right. Let me just look here. Got it. Okay. Anything more from the defense?
No, Judge.
Okay.
We're
So
gonna,
at this time, the court will find proof evident presumption great, based on not only the testimony of the detective, but also of the attached affidavit prepared by this detective. Sir, you're going to be held without bond until further order of the court. The court will also order, sir, that you're not allowed to have any contact, directly or indirectly, with a minor who has initials of MC. That is Mike Charlie, no contact, directly or indirectly. Is there anything you want to say, Mr. Atria? Okay, thank you. Mr. Miller, would you like to say something?
good luck. I've asked the court to set a bond under Preston.
Okay, pursuant to Preston and Keel, K-E-E-L, out of the 4th District Court of Appeal, the court's not going to set a bond today. The court believes it does not have discretion at first appearance in the case of this matter to set a bond, and the defendant will have to seek relief through a Arthur hearing as trial division. Thank you. No bond.
Thank you, Judge.
And then, there you go. All right, so we're just waiting for that. Okay. Mr. Gelpi, is there something I can help you with? You ready to go now? You want to wait a little while?
Up to you, Judge, whenever you're ready.
Is there a defense attorney on your side, on the other side of that case?
I heard that Mr. Benjamin had made an appearance before. I don't know if he's actually on the case.
Okay.
I heard that from counsel.
Yeah, he was in here before you took the bench, Your Honor. I guess he stepped out. I mean, I told him statewide prosecution was going to be coming here for the first appearance.
Did Mr. Benjamin want to be here?
I believe so.
There he is. Okay. Mr. Benjamin, are you ready to go, or do you need more time?
Judge, I think I need a little more time. I think the case in question is a statewide prosecutor case.
Yeah, there's Mr. Gelpy back there.
Ask her. Judge, if I could have just 2 more minutes, and
Tom,
is
you
there
do.
any kind of document for a PC or
Yeah.
something I can look at?
The client, the
Pardon?
defendant's name?
Domestic violence.
His name is Enriquez, is the last name Derek, first name.
Derek. I have a Nelson. It's not Nelson. It's Derek.
No, it's
Just give me a moment.
I think it's
Got it
Derek.
right here. I've got it.
Got it, Your Honor?
Here, you want
If I,
to take the, there's a co-defendant. Come on up.
thanks so much.
I think there's a co-defendant. Am I correct?
Yes, Judge. Douglas Carminati.
There you go. Do we know if Carminati has an attorney, sir?
Judge, Mr. Carminati has a private attorney on another case.
Who is that?
Heller, Peter Heller out of Miami.
Peter Heller. All right.
That's right, Heller?
Hold on one moment. I'll be right back. Do we happen to know Peter? You know Peter Heller out of Miami?
I know the name, I don't know him well. but-
Mr. Gelpy, have you been contacted by Mr. Heller?
Mr. Heller represents Mr. Carminati on a currently filed case. I am not sure if he's going to represent him on the new case.
Okay. Do you happen to know Heller's number by any chance? Or?
No, Your Honor.
Okay, we'll give it a shot. Could you give me Heller's number if you have it? Excuse me.
It's a separate case.
305
Oh, wait, just one moment. Okay, go ahead.
284 8000
80 what?
00.
Judge, I spoke to Mr. Heller's office this afternoon.
Okay.
Well, he indicated that he wasn't retained on this case.
Okay, hold on. May I- Okay, good afternoon, everyone. My name is John Hurley. I'm your judge this afternoon. We're in first appearance court. Today's the day the court determines whether or not there is probable cause for your arrest. We're not here for a trial. We are not here to determine your guilt or innocence. You do not need to tell us what happened. You don't need to explain yourself. You have the right to remain silent. Utilize that right at all times. But if you give up the right to remain silent, whatever you say today can and will be used against you. If you have a private attorney, please let me know who that is. We'll contact your attorney and let them know that you're in court. Now, sir, in the front row in the green, which case are you here on? Missy Jennifer Jensen.
North Broward.
Good job, Ms. Jensen.
Hold on. North Broward, Your Honor. Go.
Hello, Ms. Jensen.
Yes.
Ma'am, you're charged with a domestic battery. The court finds probable cause. Okay, Steve, do we have priors on Ms. Jensen?
One moment, Your Honor.
Sir, raise your right hand for me. Do you swear or affirm to tell the truth, all the truth, and nothing but the truth?
Yes,
Tell me your name.
Jeremy Jensen.
We can ask if you're
You're the
eligible.
husband of Jennifer?
Yes, I remember.
Yes.
I wrote it down. When your name gets called,
Now,
I'll know
let
to
me ask
ask
you,
the
sir.
judge.
Ma'am, is there something I can help you with?
I'm shocked. I'm sorry. I'm
Okay.
shocked.
Okay.
Let me ask you,
It's
sir.
shocked me. I wouldn't say anything.
Well, that I don't know about. That you're going to have to work out.
The hit
Okay.
I have a police report here saying the wife grabbed you by the hair, scratched you. You had some scratches on your neck. So I've got both pages here. It says, tell me, is there anything you'd like to tell me about this, sir?
Yeah, she's suffering some mental difficulties right now. I don't really want her in jail. When I called the police, I thought they'd take her to Baker Actor. But if she could be let out, that would be great. I'd just stay away from the house, and she could be at the home. But she's not
no.
well, and I don't
Yeah.
want to see her in jail.
Do you have kids together?
No kids.
I need you
Does she
guys to
work?
take care
Does
of
she have a
me.
job?
She's been
I'm
on
as well.
Family Medical Leave Act for a few weeks, like 3 or 4 weeks.
But I'm going to full disability.
Don't say anything,
Medication.
She
ma'am,
was
don't say anything,
Baker
please.
acted a few weeks ago, and she got out, and she tried to turn herself into the same hospital a few days ago, but they wouldn't take her again because she'd been in twice in the last 3 weeks. The same mental health psychiatric ward.
Okay, just give me a moment. Are you in fear of her, sir?
No, not really. I mean, I was afraid when she was attacking me, but in general, I'm not afraid of her. No.
Well, I'm not sure she's stable right now, and if I put her around you, I'm not sure that...
No, I shouldn't be around her right now. I don't know. But I just wanted to get help.
It's
I mean,
it's actually
I could have someone else, my dad could pick her up and take her to the house. And I'd stay away. But, I mean, she...
No, go away. I'll stay in my house.
Oh wait.
Okay.
Hold
Hold on. I need input. This is a bit of an unusual circumstance here. Hold on one moment.
Okay, I can send you the Saturday docket for the 28th,
Yes.
but I'm not.
Can you do me a favor? Okay, that's
I don't
fine.
have.
Okay, just give it a minute, all right?
I don't have a
I'm
Saturday
in
docket.
another hearing. Go
I
ahead.
only saw,
We'll
but
get
you
them
know
all
what
away.
why that could be? I only have one defendant for Sunday. So what I'm going to do is I'll forward you the email regarding that one defendant on the 1st, and maybe they didn't do a docket because there was only one. But I'll forward you
Mr.
the
Heller?
docket for Saturday right now.
Hey, can you stand by for about
You're welcome.
30 seconds? I'm finishing a domestic violence hearing right now. Okay, hold on one moment. Okay, State, I'm very concerned that she's not stable.
Yeah, I think if she could be Baker acted again, that would be probably the best, from my opinion.
Here's what I'm going to do. I'm not going to Baker act her. I'm going to have her sent over as soon as possible to see Judge Lerner Wren. Judge Lerner Wren is the expert mental health judge, and I know that she doesn't normally do domestic violence cases, but this is a special. I'm going to get her. You know what? I'm going to get her over there as soon as I can. But I don't think I should. I'm going to set her bond today at $1,000, and I need this to go to Judge Lerner Wren as soon as possible. Sir, I don't, just by what I'm witnessing here in court, I don't think it's safe to put her out, not only for herself, but maybe for you, until we have a judge who's got expertise in this type of matter to look at the situation. All right?
Okay.
So that's what I'm going to do. I'm going to have it sent over to Judge Lerner Wren as soon as possible.
Okay, so what does that mean for me now?
Well, her bond is $1,000. If
So
nobody bonds her out, she'll stay in jail. She'll see the mental health judge probably tomorrow. Okay? That may be the best avenue. All right?
Okay.
She's in a mental health facility right now at North Broward. That's what they do up there. They are there for mental health patients. So she's in a place where people are paying attention to this. All right?
Okay.
Okay, sir. I appreciate it. Thank you, ma'am. I'm going to order for the time being not to have any contact with your. You know what, sir? Is it okay if she calls you?
Yeah, she can call me.
You can call your husband, but stay 500 feet from him at all times. All right? Okay, ma'am. Thank you. Sir, thank you.
Okay, thank you.
Okay, now, send this over. Now, Mr. Heller, are you there?
Yes, sir.
Okay, Mr. Heller, let me ask you, we have the statewide prosecutor here, Mr. Gelpi, and we have the co-defendant and the co-defendant's attorney here also. Are you going to be representing Mr. Carminetti? I've heard differing opinions about that.
Well, at this point, I represent him on an existing open case. That's a 2014 case. My understanding, though, and unbeknownst to me until I pulled it up this morning, that this is and I did speak to Mr. Gelpi this morning about it, this is a 2015 case. It's a different case. I don't know the details. I'm not retained at this point for the new case. I did talk to his family about at least retaining me for purposes of a first appearance in a bond hearing. I have not heard back yet.
Okay.
I intended upon coming up to see him tomorrow in the morning.
No problem. Thank you for checking.
Talk to him and see what his,
All right, bye.
what his desire is. But
I understand.
I thought this was part and parcel of the old case, but it's not.
Right. Okay.
At this point, I have not been retained for a new case, and I do need to talk to him. In fact, I just left a message for Mr. Gelpi. I wasn't aware that he was in court.
Yeah.
Right
Would
now.
it be better if I reset this case for tomorrow afternoon, sir?
The only problem I have, well, you can do that if you like, Your Honor. The only problem is that I'm going to have a first appearance. I have a client coming in from out of town today, and he's going to surrender in the morning to the federal, to the FBI, and then he has a first appearance in Miami at about 1:30 tomorrow afternoon from Miami. So I already have that scheduled. I would be happy to report to you. I mean, I'll go see him in the morning, my client, see what he wishes, and then report to you before that. But I don't know what else to do because I already have this prearranged for my client surrender.
Right.
Federal case tomorrow morning.
Well, he's got $1 million bond at this time. So what I can do is, why don't you contact my office tomorrow? I'll reset this case for tomorrow afternoon. Contact my office. Let us know what what you've worked out with your client, and then maybe worst case scenario, I can roll it till I can roll this for Saturday and let a judge on Saturday if you can do that. How's that?
Okay, well, that's fine. But I wanted to at least, I owe it to my client to at least come and see him and talk to him.
I understand.
Let him know what's going on.
Yes, sir. Okay. I'll reset this for tomorrow at 1 p.m. Thank you.
Okay, thanks so much, Judge.
Would you like my office number, sir?
Yeah, I think my secretary might have it, but let me.
Okay, we're going to reset this for 1 o'clock tomorrow. Now, we ready to go on your case, Mr. Beck?
Yes, Your Honor.
Do you have the paperwork still? Did I?
Yes, I'm going to pass it back to Your Honor.
Okay. Thank you.
Do you have any children that rely on support? Do you have any family in Southport? Any money in the bank? Land or real estate? Who's going to help on you out? Your family?
Do we have, all right, Mr. Derek Enriquez?
Yes, Your Honor.
Sir, you have the right to remain silent today. If you give up that right, whatever you say can and will be used against you. Do you understand that, sir?
Yes, I do.
You're being represented by a very fine attorney. You do not need to make any comments. Allow your attorney to speak on your behalf. Is that clear?
Yes, sir.
All right. Good afternoon, Mr. Benjamin. How
Good
are you?
afternoon, Judge Jamie Benjamin on his behalf. Judge, I'm here, also his wife is here, and also his brother is here, and also a lawyer who's represented him in the past, Mr. Glenn Kreitzer, is also present, although I'm representing him at this point for the bond hearing.
Okay.
Judge, I've had a chance to look over what little probable cause affidavit there is. It's a strange situation where I see a conclusive, and I don't usually even address probable cause to argue the issue of probable cause, but all there is a conclusory statement that he was involved, or whatever the word is, with some conspiracy without any facts to support it whatsoever. Although there's a bond assigned, it looks like there was a request for it by some agent, and it looks like Judge Robinson, although I'm not 100% certain of the signature. I think it's Judge Michael Robinson, but I'm not sure because it's so pen scratching.
Sure.
That who signed a conclusory document setting outrageously high bonds on a case, and there's nothing more. So I mean, he is I'd like to offer and argue his significant ties to the community, his significant family ties and property that's available to post. And I know there's a Nebia requirement attached to the arrest warrant, but these amounts of money are just draconian, and they're tantamount to a pretrial detention, which they haven't filed for pretrial detention, and it is because it's ridiculously high. So, I mean, if I could offer that to Your Honor as a proffer.
Let me just say this.
Sure.
As a practical matter, I do note that it's someone typed up at the top, bail may only be modified by the trial judge to whom the case is assigned, the chief judge of the circuit. There's a case right on point, State versus Norris, Norris, and I believe that's out of the Florida Supreme Court within the last 10 years, that basically says that kind of writing can never handcuff or restrict the first appearance judge from looking at the bonds de novo. However, as a practical matter, there's a Nebia requirement. Now, even if we looked at the bonds and jumped into a bond hearing, the bottom line is, at the end of the day, he's got a Nebia requirement for anything. So I just think really the best thing to do is to go ahead and just take everything instead of piecemeal. Let the bond and the nebia go on to the trial judge and let the trial judge handle the whole thing.
And the only reason I would argue against that at this time, Judge, is that we believe we can put together a nebia package quite quickly. His mother and also his wife's mother, and they've been together 24 years, married for 13. Those two families have property that are worth numerous hundreds of thousands of dollars, but they don't reach the 900,000 available. That it could, and I believe, Judge, I could argue to Your Honor and show by the proffer that if Your Honor would come down to some other amount, like somewhere near half that, we could put a nebia package for 500,000 together based on both moms' properties that they've lived in all their lives, that are free and clear, that have respectfully 300 and odd thousand each, give or take, and I can explain that further. But then we can put a nebia together and get it to the statewide prosecutor. I've done that so many times where they approve of a nebia package.
Sure.
But if we have to wait for another judge to look at a bond reduction, this is already Thursday. We were not going to get there till middle of next week.
Let me ask Mr. Gilbert.
Anthony Bart.
How are you, Mr. Gilbert? Statewide prosecutor. Sir, let me ask you a question. Do you have any more documents like probable cause?
Private counsel.
On this that the court could review?
I have lots of documents, including financial documents. The information is so
Were you working on it before that?
we find ourselves in a position where there's at least two other individuals that we're looking for.
Do you have any children? How old?
I understand.
In our case.
Families in Florida?
Let me ask.
In the bank?
Say that I would want to address
Land and real estate? And who's gonna help on
the
you?
search warrant last night, I was looking at Mr. Enriquez is a danger to the community. I think probably the most,
Would you mind just scoot toward the microphone a little bit?
probably the most concerning thing is that last night during the search, Mr. Enriquez, who is a convicted felon, in his safe was found an automatic shotgun and 2 assault rifles with 4 magazines with 30-round clips. So the fact that he's a convicted felon, he chooses to arm himself in this way, makes him more of a danger to the community than we even anticipated before. And the court should know that Mr. Carminati, Mr. Enriquez was actually Baker acted in June of this year, June 4th. He had to be pulled out of the house, the very same house that was searched last night, by a SWAT team. I take that back. The SWAT team responded. After 4 hours, he finally surrendered due to the intervention of his brother. He was then Baker acted, and shortly after, there were more violent incidents that were reported
How long
to the
ago
police.
was the SWAT team out there with the
June
Baker?
4th of 2014.
Okay. And then you say last night he was found to have the automatic shotgun, the
2
high-powered
assault
rifle,
rifles.
and you say he's a convicted felon.
Yes,
Tell
sir.
me about that.
Well, he's been. I don't have a complete workout on his arrest. He's been on his priors. He's been arrested many times, dating back to I think 1990. I want to say. But his last prison stretch was a 5-year prison stretch for possession with intent to distribute cocaine. That was a federal prison sentence. I think he came out, I want to say it was 7 or somewhere around there.
Okay. So I'm assuming by what you've told me now that you would not be willing to stipulate down from the bonds that have been set previously of $1 million. Is that correct?
No, Your Honor. At the appropriate time, I think the state will be asking for an increase in bond, again, based on what we found in the house. And there was also some more financials. I don't want to get into all the details, but there's a lot more. But that's the most important thing is the assault weapons and the fact that he's a convicted felon.
I understand. Go
Just
ahead,
briefly, Judge, and the only thing I can address is, my understanding is there was a locked safe that was in the house, that all of the firearms were locked away in a safe, that there's no evidence that that Mr. Enriquez had any ability to open that safe. So whether or not, and this...
Let me ask, whose home was that? Whose home was that?
It's his home. He and his wife, Myra, lived there. The safe was in the garage and control of the people that live there.
You know, Mr. Benjamin, I'm reluctant today to go near this. This does not. This seems like there's a lot more to this, and drug trafficking and.
Because the case was ancient. It was about 15 years ago, and it was involving what I was told was 1 kilogram of cocaine in another state. He did do a prison sentence, but he got out over 7 years ago. So.
My point, though, is drug trafficking, high-powered rifles, automatic shotgun. It paints a picture of the court that gives the court great concern. And even though the court believes that it does have the, based on State versus Norris, does have the discretion circumstances like this to adjust bonds, the court's reluctant to do it in this circumstance.
We'll approach whoever the judge is. We think it may be Judge Robinson immediately and try to set an emergency bond hearing.
I understand.
In that court. But thank you for listening,
Mr.
Judge.
Benjamin, thank you. Sir, you're very fortunate to have Mr. Benjamin. He's a very fine attorney, all right? Thank you, Mr.
Thank you, sir.
Benjamin.
Thank you, sir.
Response remain at $20 for the attached orders regarding Nebia. Okay. Sir, may I help you? May I help you, sir? Are you here on a case?
I represent.
Oh, okay.
Mr. White.
Yes, sir. All right, thank you.
Glenn Kreitzer, by the way.
Oh, thank you. Nice to see you. Okay. May I see Corey Studemeyer?
Corey? Hey, Judge.
Studemeyer, you're charged with a domestic battery. The court finds probable cause. Do we have any priors, Mr. Studemeyer?
Well, okay, Your Honor. I'm sorry, Judge, the system's running slow at the moment. I don't know if you want to inquire while...
Got Mr. She grabbed her hair, dragged her around the park, located near the residence. Mr. Miller, is there anything you'd like to add on this case today?
Were there any priors? I didn't hear those.
We're waiting. I think the computer's running slow.
Oh, well, okay, so Mr. Studemeyer has been living in South Florida for about 7 years. He's been at the same address for 2. Currently works at McDonald's. He's been there for about 7 months. He has a 1-month-old child that he takes care of. All of his family lives here in South Florida, so he has very strong family ties. No money in the bank, no real estate. He does have a place to stay, separate from the alleged victim, while this case is pending. He's hoping his family will bond him out. The one thing I would point out regarding the case, if I may, Your Honor, the officer that investigated this case did not see any visible injuries on the alleged victim of the case. All of the information came from the alleged victim's mother. The alleged victim made no statements at all regarding this case. And I would argue that there is no probable cause based on the fact that the witness didn't have any participation in, the victim had no participation in the case whatsoever. So I would argue that you don't even have probable cause to hold him on this. And if the court does find probable cause, I would ask you to set a minimal bond order release and free trial.
Yes, sir. The court will find probable cause today. State, do you have priors on this gentleman?
2012, resisting without violence. 2011, possession of marijuana. 2005, out of Palm Beach, possession of a weapon or firearm or ammunition by a convicted felon. Sentenced to 4-year state prison. Additionally, false ID 04 out of Palm Beach. Possession of cocaine. False ID 04 out of Palm Beach. The possession of cocaine out of Palm Beach 02. Burglary 01 out of Palm Beach.
Miss Ashley, was there contact on this matter?
He had a domestic violence 01 out of Palm Beach. And, Your Honor, I see he's been arrested 1, 2, 3, 5, 6, 6 times for failing to appear in court. That's what the clerk will have it. Sure. Could you have someone make me a copy also?
Sir, I'm gonna
No.
no contact. So I'm gonna set your bond today at $1,500. I'm gonna order that based on your criminal record, the facts of the case, order you have no contact directly or indirectly with Pamela DuBose. Do not call her, do not text her, do not email her. Stay 500 feet from her at all times. That's where she lives, works, goes to school. Anywhere in between, you're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you, sir. Missy,
Thank you, Judge.
Michael Gonnelly.
Connolly?
Thank you again, man. I appreciate that.
Here, good luck. Mr. Connolly's present at the main, Judge.
Battery, domestic violence-related count 2 is a domestic battery by strangulation. Court finds probable cause. State, do we have any priors on this gentleman?
He went through diversion in 97 for assault and battery.
Okay.
That was out of date.
Assault and battery and 97. Anything you'd like to add, Mr. Miller?
Judge, Mr. Connolly is a 25-year resident of South Florida. He's been at the same address for the past year. He works as ATM service route. He's been doing that for about 4 years. He has strong family ties, no money in the bank, no real estate, does have a place to stay separate from the alleged victim while this is pending, and he's hoping that his family and or friends will help to bond him out.
Okay, ma'am, Miss Ashley, was there contact in this matter? No? Okay, victim and mother also lives in the residence, need like here?
You know, I'll just call the victim in that other
Pushed.
case.
Place his hands around her neck, strangle her.
We'll go on my report to Boca.
Punched her twice on the right side of the face with a fist. She had abrasion on her cheek, swollen lip.
The only reason
Threatened to beat both of them with his shoe. So, sir, based on the level of violence, the court's concerned for the safety of the alleged victim. Count 1 will be 1,000, but count 2, the court's going to set that bond at $9,000. Your total bond today is $10,000 based on your prior assault and battery and the facts of the case. The court will order that you have no contact with Ms. Machado, directly or indirectly. And no contact with, I'm not sure who the other person is.
Here, can I give you...
Ms. Machado and her daughter. No contact with either person, directly or indirectly. Stay 500 feet from both of them where they live, work, go to school. Anywhere in between, you're not allowed to possess guns, weapons, firearms, or ammunition while you're on release. Thank you. Okay. May I see Jennifer Cannon? You know what? Let Miss Cannon have a seat. Let me see here. Missy Alternisha Nabby. Alternisha Nabby.
Present at the main, Judge.
Okay. Miss Nabby, you are charged with a petty theft on count 1. You're wanted out of Dade County for a theft. So.
Judge, this is a 4-year-old juvenile case, according to Ms. Nabby, that apparently has been resolved in her favor. Somebody apparently used her ID or used her name when they got arrested for a retail theft. I would ask the court to consider an ROR on this case. Let Miami-Dade come get her so she can get back to Miami to deal with this. She's a high school senior, and you're due to graduate, right? And she's due to graduate, so we need to try to resolve this as quickly as possible.
Yes. What's your position?
I don't think Ms. Nabby has a lot of credibility right now, considering she's out in a theft, is allegedly committing a new theft, and not showing up to court in Dade.
Can we tell?
It's a juvenile. I mean,
Yeah. Sir, ma'am, you want to plead no contest to the theft here in Broward?
One moment, Your Honor. I'm explaining to her what that means.
yeah. Here's the defendant's information. I'm gonna write down the name of the phone number of the victim. And look at the case called an attorney. So you can get out of here. What? Well, I'm gonna write the number. I wonder why the girl isn't on the docket. Is she gone down? The girl, there's two co-defendants.
Okay. Yes, Judge.
Okay, ma'am. Count 1, petty theft. You plead no contest. That case is over with today. We're not going to have a trial. We're not going to appoint an attorney. Wrapped up right now. You don't come back on this case. However, you'll still have to be transferred to Dade County to address that matter, all right? Okay, how do you plead to count 1, ma'am?
Contest.
No contest.
Okay, ma'am, I'll accept that. I'll withhold adjudication. Good luck, ma'am. Thank you.
Your Honor.
Thank you, Judge.
Possible
Good luck.
if we could call it a case at a turn only because I'm going to need our victim advocate to call and speak with the alleged victim, and it's the only case that's keeping her here right
Okay.
now. It's Anthony Vargas.
You see Anthony Vargas? Toward the end of the docket, I'm going to show the last couple of pages. Robbery by sudden snatching, false imprisonment, neglecting a child without great harm, and battery. I'm not sure if I...
Hold on. If it's the false imprisonment issue, Your Honor,
Go ahead.
the allegation is that she, and I spoke with Ms. Hendricks, she was trying to get on the bus. He stepped in front of her to prevent her from being able to get on the bus and get away from this situation. Your
Okay,
Honor.
that's not in the
Okay.
PC.
Yeah, it is.
Is it?
On the second page. Once Hendrick was able to get up, she stated that she tried to get onto a bus to escape the assault, but Torres got in front of her and prevented her from getting on the bus. It then stated that both Torres and Vargas grabbed her and prevented her from leaving on the bus.
Okay. Now, what about neglecting a child without their great harm?
That allegation is because it says in the next paragraph they left their 2-year-old child in a stroller approximately 10 feet away with no visual or physical control over the child.
Okay. Okay, so their child, I wasn't sure.
Yes.
Okay, so, all right, Mr. Miller, I'm going to find probable cause for each and every count. Does this defendant have any priors?
Your Honor, he had a possession of marijuana in 2012.
That's it?
Yes. The concern is, as I mentioned, I spoke with Ms. Hendrick. She was actually at the hospital. She started feeling pain, soreness in her neck. She went to have it checked out. It looks like she's going to be okay, though. She's just really concerned. She knows that Mr. Vargas and through Mr. Vargas, Ms. Torres know her schedule. She was actually at this bus leaving work. This is the bus she takes and the bus stop she takes when she's going home from work. She's just concerned that her schedule is so well known because she dated Mr. Vargas for approximately a year. Your Honor, what we would be asking for is a bond increase and pretrial release with a GPS monitor.
Was she harmed? Was she injured at all?
She was, her neck, she's feeling soreness in her neck, Your Honor, is what she told me. The reason she didn't seek any medical treatment at first is I guess there's a lot of adrenaline. She wasn't really feeling anything, but then today she went to the hospital. She had some x-rays done. It looks like nothing permanent or anything, but she'll be all right, but she is sore.
Okay, Mr. Miller, is there something you'd like to add?
Judge, this clearly did not happen in a vacuum. There was something going on here, some kind of back and forth between the alleged victim and my client and the other person involved. He's been living in South Florida for 4 years, been at the same address for 4 months, has a job at Jade Alexander. He's got a child that he takes care of. Strong family ties, no money in the bank, no real estate. We would ask the court for a straight pretrial on this. we don't have any objection to stay away order, but I didn't hear any crimes of violence in his past. Well, and this is kind of an anomaly for this man. And like I said, this didn't happen in a vacuum. There's more going on here than it's on the PC.
Let's
kind of wrap this up.
Well, I just want to let the court know what was going on is actually mentioned in the PC, Your Honor. This was people making false claims to one another, and Ms. Hendrick admits I believe Mr. Vargas made claims that he had nude photos of her, so she made a claim about something with the phone involving Ms. Vargas, and I think bad judgment on all sides. The problem is that then, and with an independent witness, Mr. Vargas and Ms. Torres brought violence into it. That's where the problem is.
Sir, I'm going to set your bond on count 1 at 1,000. 2, I'm going to release you on your own recognizance. 3 and 4 will be 1,000. Total bond's $3,000 today. All right, sir. Thank you. I'm going to ask.
Thank you, Judge. Thank you.
Hold it, sir. No.
Sorry. Wait.
Sir, no contact with Amanda Hedrick. Don't have any contact with her and stay 500 feet from her at all times. Thank you.
Okay. Thank you
All
very
right.
much.
What about Kimberly Batista, Michelle Glander, and Latavia Bertrand? Miss Batista, where are you? You know what? Hold off on Batista.
None of those people are here at main jail.
Hold on on Batista. How about Michelle Gallander?
North Broward.
I understand, ma'am, you're charged with trespassing, and the court finds probable cause. Let me just look here. All right, Miss. Any priors on Miss Gallander?
One moment.
Miss
Judge.
Gallander, are you working at this time, ma'am?
No, sir.
Okay. What do you do for work when you do work?
I was staying with my family and helping them out.
What are you helping them out with?
I don't have a job. I was going to look for a job.
Okay.
Recently.
Yeah, she's, without seeing even what they're for, I know in the last 5 years she's had 12 arrests. Her most recent was February 17th, and that was for loitering for prostitution. She was ROR'd.
Ma'am, would you like to resolve your trespassing case today? Plead no contest. It's
Yes.
over with. How do you plead, ma'am?
Yes, sir. No contest.
Okay, you understand we're not having a trial. You're not going to have your day in court. The case will be wrapped up. It's over with right now. Is that what you want to do?
Yes, sir.
Okay, I'll withhold adjudication, ma'am. Thank you. Latavia Bertrand.
Excuse me, Your Honor, that Batista is a medical reset.
Okay, so we'll reset Batista tomorrow, Friday p.m. I'm going to find probable cause. Okay, what about Latavia Bertrand?
North Broward.
Hello. Hold on a second.
Ms. Bertrand, possession of cocaine, 1,000, probation violation, no bond. Thank you, ma'am. Violation, probation, no bond. Thank you. How about Jeffrey Moise,
I'm gonna address that.
Jeffrey Frederick, and Brendan Davis? Mr. Jeffrey Moise, I have good news. Your bond has been posted by alternative bail bonds. You'll be out of jail shortly. Thank you, sir.
Thank you, Judge. Good
How
luck.
about Jeffrey Frederick? Violation of probation, 5,000. Thank you, sir. How about
Good luck, Mr. Frederick.
Brendan Davis? Brendan Davis.
President of the Maine.
Sir, paraphernalia, drug paraphernalia, court finds probable cause. Sir, your bond's been posted. You'll be out of jail shortly.
Good luck.
Probable cause found. Thank you.
Just listen for your name, guys. He'll call you up.
How about Derek Wiggins? Derek Wiggins?
He's inappropriate, Your Honor.
Then I would just say I think he's had his chance, man. I mean, because this has been since the 3rd.
Hold on,
and if
let
he
me
can't act
look at
appropriately.
I'm I'm going to release him on his own recognizance, all right? How about I'm going to releasing Mr. Wiggins, ROR. Okay, how about Walker Levinsky? Sir, you've been charged with possession with intent to sell, deliver cannabis, possession of cannabis. Court finds probable cause. See, do you have any priors on this gentleman?
Trace, do you have anything?
Open money laundering out of Arizona. Sir, I'm going to set your bond. 1,000 on one, 1,000 on two. Thank you. No, 1,000 on one. Yeah, and 1,000 on two. Thank you. How about Vincent Stanley? Vincent Stanley.
I'm sorry, Judge.
Yes, sir.
What happened with Mr. Levinsky?
He has an open case, a felony case out of Arizona. So based on the amount of drugs alleged, you'll wait. I'm going to just leave his bonds where they are, all right?
Thank you, Judge.
Thank you.
Okay, $200 to a buck.
Which case are you on today?
Your name?
Michael, we'll try to get you out of here.
Stanley? Are you?
Domestic.
Michael Donnelly? Did I already do that case?
Yes.
Okay. Here you go. Do you have the paperwork over there I can look at somewhere? Sorry about that. Just give us a moment, all right? Okay, Michael Donnelly. You want to step right up here? Right up there? Yeah, right there. That's fine. Okay. Okay, ma'am, raise your right hand for me. Do you swear or affirm to tell the truth, all truth, and nothing but the truth?
Yes.
Okay, tell me your name.
Jeanette.
Excuse me?
Jeanette.
Ginez?
Jeanette.
Ginez. Okay, is that your last?
With a T.
Is that your last name?
My first name.
What's your first name?
Jeanette.
Okay, what's your last name?
Gonzalez.
Gonzalez, Miss Gonzalez. Okay. Do you have the paperwork on that Donnelly case?
This is the strangulation.
Oh, you did? Oh, sorry. Okay. Ma'am, I already took care of the case. I set his bond at $10,000. I think I was told by somebody that you were in fear of him. Is there anything you'd like to tell me, ma'am?
Yeah. When that person called, she asked me if I was in fear of him, and I told her that I didn't know how I felt.
Okay, that's fine. Now, all right.
However, when she told me on the phone what the charges were, and I looked up strangulation, and I looked up the definition of it, and what it is, like when you get charged with strangulation.
Speak up for me a little bit. Just raise your voice because I can barely hear you.
I looked up the information about what she gave me that he was being charged with.
Okay.
And I looked up that strangulation means that he would hold my neck until I couldn't breathe.
Right.
But that is not really what happened. He
Okay.
did hold my neck,
Right.
and he let go right away.
Okay.
So he squeezed, but he let go. I mean, at no point really did I feel that I couldn't breathe.
Right.
And that's why I came to specify.
Did you feel lightheaded at all?
I did
No?
not.
How long did he hold your neck?
Probably less than a second.
Okay. Has he ever harmed you in the past, ma'am?
Never.
Never? Has he ever threatened to harm you in the past?
No, not really.
Well, no. You looked up for a moment. You shook your head. Has he threatened to hurt you in the past?
No, I mean, he never seriously.
What do you mean by that?
I mean, we were joking. I mean, I said the same thing to him. And we never really mean anything that we say like that. We would
Do you have children? Do you have children together?
Not yet, but we were planning on it.
Okay. Are there drugs or alcohol involved in any of this, ma'am? Anybody?
No.
No? Does he ever carry any guns or weapons with him?
No.
Do you believe that Do you believe that he represents a danger to you? Is that your mother right behind you?
Yeah.
Okay. Does she speak English?
No.
No English? Where's she from?
Cuba.
Cuba. Okay. Can you tell your mother in Espanol, ask her if she could walk up here and let me, I want to look at her face. Hola.
Hola.
¿Cómo está? Stand right here, right here. Right here, ma'am. Gracias. Just wait. There's enough on the paper to show me that there is probable cause. Doesn't mean he's going to get convicted, but I have to tell you, I took a look at your mother, and she looks like she's been beat up, and she had a black and blue mark on her chest. She has a black eye under her right eye. She has a swollen cheek over here, and that wasn't from one shot. That had to be several different punches to your mother.
Punched her twice.
Well, if he punched her twice, that, well, maybe he's got a big fist, but she got a black eye and a swollen lip from one punch. That seems like, okay, well, and then I do note he's 6'4". I think how big is he? He's a big man. 6'4", 300 pounds, I believe. It's a big man, and your mother's, she's I wouldn't say petite, but on the small side. And I can only imagine the force that she received.
Well, he really didn't look behind him. He was in front of me. She was behind him.
Let me just say this, ma'am. It was more than one punch. So, I understand this isn't easy.
He turned around and he was in the moment heated, and before he realized it, when he realized it, he stepped away and helped her up.
I understand. Well, ma'am, I appreciate you coming to court today, and tell your mother I said thank you. Gracias. Gracias. Okay, but ma'am, I'm going to leave the bond where it is
What
today.
does it mean that a $10,000
$10,000 bond.
What does that mean?
That means that, is he working, ma'am?
Yes.
What does he do for work?
He works with my father in his
Doing
company. What? He fixes ATM machines.
Does he live in the same home with you too?
Yes.
Who would put up, I'm not asking you if you would do it, but who would put up his bond?
We don't have money like that,
Okay.
neither one of us.
Here's what I'm going to do. I'm going to lower his bond, and I'm going to put a GPS monitor on him. Okay, so I'm going to split the baby a little bit, all right? Okay, there you go. All right. Messi Vincent Stanley.
Judge, I'm sorry, can I interrupt here?
Yes, sir.
We have a young lady here, Brittany Swanson. She's on page 5 of the docket. The bailiffs are trying to get the girls out of here.
Her name is Swanson?
Yeah, she's on page 5 of the docket, but she's marked out. I don't know why.
I don't know. I don't have the paperwork for it.
Okay, so you have to real bond.
But I don't.
All right, what's your dad's name?
She's not on the docket.
Do you have the paperwork for it?
Not going to have it because once marked out means they're not on the docket.
Did she bond? Did somebody bond her?
Checking that. Yeah, her bond's been posted.
Okay, your bond's been posted, ma'am. That's good. There you go. All right, now we've got Vincent Stanley. Step forward, sir.
President's Maine, Judge.
Mr. Stanley, please listen to what I'm going to tell you. You have the right to remain silent. You're not required or expected to make any comments today about your arrest, but if you give up the right to remain silent, whatever you say today can and will be used against you. Everything today is being recorded. Do you understand what I've explained?
Yes, sir.
Do you have a private attorney?
No, sir.
Okay. Now, sir, you've been charged with murder while engaged in a certain felony. I believe the felony would be a burglary, am I correct?
Or burglary or robbery.
Burglary or robbery, all right. Now, State, are you seeking a foreclosed bond and release conditions today?
Yes, Your Honor.
Okay. Now, Mr. Miller, do you have any comment about whether or not there's proof evident presumption great today?
Yes, Judge. I would argue there is not proof evident presumption great based on the identification of Mr. Stanley as the alleged perpetrator of this crime. According to the probable cause affidavit, the eyewitness, Thomas Dwyer, tentatively identified Mr. Stanley. Another witness, Shabby Jackson, said that Mr. Jackson favored a person that she identified as a person getting into a car. Linda Smith apparently identified Mr. Stanley as a person she saw leaving the house, which may place him at the scene, but doesn't necessarily as the perpetrator of the crime. And what's missing from this is the other eyewitness, Josine Pierre, who is not consulted at all and makes no identification. She's not mentioned in the police report at all. And so I would argue that you have an identification issue where there is at least reasonable doubt based on the statements or the lack of statements and the statements of the 3 witnesses that Mr. Stanley is the person who was identified as the perpetrator of this crime. And so I would argue that he's entitled to a bond based on that alone.
I understand. Thank you, sir. Mr.
Your Honor, I would just argue the problem with that argument is that it leaves out that it corroborates the information provided by Israel Brown, Your Honor, who's charged as an accessory after the fact, that informed the police that he was with Mr. Stanley, that Mr. Stanley was in the area. He went there, the admission he made when he came back to Mr. Brown. And I think after taking that information, the identifications just corroborates that information, Your Honor.
Yes.
Response, Judge?
I'll give you a brief response.
Very
sir.
briefly.
Yes, sir.
Mr. Brown lied to the police at least 3 or 4 times, gave different stories to the police 3 or 4 different times. He's not a reliable witness. And I would argue that we still haven't reached proof evident presumption great.
Okay, sir, I'm just going to say thank you very much, Mr. Miller. The court does note there was a shooting February 26, 10 a.m. in the morning. A person named Kenel Jean was found shot several times. It was determined that the victim, I'm reading these facts just because there are some moving parts, and I want to be clear for the record why the court's doing what the court's doing. It was determined that the victim and his wife, Miss Pierre, were looking to purchase a residence in the city of Fort Lauderdale when he was shot during a robbery. The victim and his wife were being shown the property by a Coldwell Banker agent, Mr. Dwyer. It says that the deceased was declared deceased or pronounced deceased at Broward Medical Center. The victim's wife and Dyer gave sworn statements that they were inside the house looking at the property when a black male gunman entered through the open door of the residence. The victim began to struggle with the gunman, at which time the gunman shot the victim several times. There was video surveillance footage from a nearby residence. The suspect is shown fleeing the residence on foot and is seen on video from another camera system at a local car wash, jumping into a Pontiac Grand Am. And it says that they learned from reviewing the video that approximately 9:30 a.m. the previous day, another realtor was showing the residents at that time when a white Pontiac Grand Am pulled into the driveway across the street from the same home where the person was shot the following day. It says that there were witnesses to the events that said a similar Grand Am frequent the drug areas in the area of Tatertown, which is out by it's on the west side of the sheriff's office, right out here on Broward Boulevard in West Fort Lauderdale. It says that his co-defendant or co-arrestee was the driver of the vehicle and backed up what other witnesses said, that he was the one who drove this defendant to the crime scene, drove him away from the crime scene, and even stated that this defendant admitted that he had shot someone. And it says that one person positively identified this defendant, and the other two, granted, were not 100%. However, so what we have is we have a co-defendant or a co-arrestee who says he was the driver, the Grand Am, they have the Grand Am on video. We have a positive ID by one person, and then we have two IDs which were not 100%. They were kind of general, that kind of looks like him kind of IDs. So, that being said, the court does believe it does meet proof evident presumption great today, and the defendant will be held without bond for the murder of Canel Jean. Is there anything you want to say?
I would ask the court to exercise its discretion pursuant to Preston and set a bond in this case.
Okay, pursuant to the Preston case and the Keel case, KEL, out of the 4th District Court of Appeal, the court will order the defendant be held without bond. The defendant's only manner of relief is to have a full-blown Arthur hearing before the trial judge. The court believes it does not have discretion first appearance to set a bond at a first-degree PBL where proof evident presumption grade has been found. Thank you very much. Okay. There you go. Okay. Now, Mr. How you doing? Hey there. Do we have the city? Do we have the prosecutor here?
Judge, no, but he left me notes indicating everything that he wanted to do.
Okay, we're gonna have to.
He's in a non-jury trial.
Okay, so we've got. Let me just see one more. Franklin Barahona.
He's present at the main
Sir,
judge. We're going to need a phone
135
order
are all
for Mr.
no bond, violations of probation, pretrial count 6, resisting arrest 100. Thank you.
Mr. Atria, we need a phone order for Mr. Barahona, please.
Okay, Nelson Enriquez.
Here, that's fine. Here, I'll show you. Oh, well. Oh, I thought you said if... Yeah, that's what I'm saying. I'll show you. Just give me their... What's the first name? Oh, hold on.
Nelson Enriquez.
Yeah, I'll take care of it right now. Okay. Well,
Sir, battery on a police officer resisting...
Right,
I just want to finish the state cases, Mr. I got this one left. Battery on a police officer, resisting arrest with violence, resisting arrest without violence.
Your priors?
Court finds probable cause on this...
Just we're... Ms. Wright is checking for priors, Your Honor.
Okay, hold on one moment. Mr. Nelson Enriquez, battery, police officer resisting without violence, and State, do you have any priors on this gentleman?
Yes,
oh,
Your Honor.
You have juveniles, right?
Well, first off, just so you know, he has a warrant from December 15th. It's Miami-Dade County pickup only. It's on a possession of marijuana misdemeanor. And yes, there are juveniles.
Mr. Miller, would you like this defendant's juveniles to go out to you right now, or would you want me to go sidebar for these?
Sidebar works for me, Judge.
Okay. Mr. Miller, what would you like to say?
Judge, Mr. Enriquez, 17-year resident of South Florida. He's been at the same address for the past 3 months or so. He works at Olive Garden. He's been there for 8 months. He has a child on the way, strong family ties, some money in the bank, no real estate. He's looking for his family to bond him out. And we need a photo order for him, please, Mr. Atria.
Okay.
Who?
Photo order for him.
Barahona? Who is it?
And Enriquez.
Enriquez. The other guy was a phone order.
I gotta tell you, Mr. I'm gonna knock off the $100 on the count 3 for you, sir. But your bond on count 1 and 2 are going to be $1,500 based on your juvenile record. Thank you, sir, and the facts of the case. Thank you.
Thank you, Judge. All right.
Yep.
There's 150 now.
Now, okay, may I see Marvin Bush, please?
Conti, Your Honor.
Trees. Meanwhile, that woman yesterday, where like.
Okay, hi, Mr. Bush.
Hello, sir.
Good, you're here on a battery. I don't remember
Yes,
what
sir.
Marvin Bush is about. Just give me a moment, sir.
Hey, Debbie, it's Eric. You can come down if you like. All right, thanks.
Okay, so let's look here. Push the wheelchair, I remember, then to the nurse. Okay. Mr. Marvin Bush, let me look here.
Yes, sir.
Now, I have your address, the shelter out there on Blunt Road. Is that right?
Yes, sir. That's where I was located at the time.
Well, how long have you been out there?
Going on a month now.
Where were you living before that?
At my mother's in Miami Gardens in Miami, Florida.
Hold on.
Hope I can get back there. The shelter has like $600. The shelter has like $600 of my money right now, waiting for me to come and pick it back up.
Yes, Judge.
Let me ask you this.
Yes, Judge.
I'm gonna go. South. Sir, I'm going to send you to your next judge, all right? Thank you.
Judge, I have Mr. Douglas back at the main. He's a
Your Honor?
reset from this morning. Toucher strike battery.
Your Honor,
Yes, sir.
the only other person on the second look docket, Quentin Shivers,
Yeah.
he had to be removed due to his behavior.
Okay, so
Aw.
we'll reset him, all right?
Okay, thank you, sir.
Thank you.
Just
All right, what do you have, Mr. Miller?
On the last page of the docket, a reset from this morning, Christopher Douglas. It's a toucher strike battery. Mr. Douglas, you want to come up now?
It should be at the end.
All right, Mr. Douglas, you're here for a battery, allegedly pushed the victim for no apparent reason and attempted to hit him again with his closed fist. It's really okay. Victim defended himself in fear for his life. Okay, so, Steve, do you have any priors on this gentleman?
2014 theft, 2014 theft and failure to leave property upon order from owner, 2014 theft, 2014 theft, failure to leave property upon order from owner, 2014 battery and trespass, 2014 possession of cocaine, drug paraphernalia, and theft with the VOP.
So I'm going to send this on to your trial judge. You have a prior battery. Thank you, sir. Okay.
Thank you, Judge. We're clear at the main.
Thank you. May I see Jennifer Cannon, please?
Just letting you know we're done.
Jennifer Cannon.
Thank you.
Jennifer Cannon, Gordon Koish, and... Yes, sir. Go ahead. It's going to be Cannon, Koish, and... Let me see. Cannon bonded. Okay. And is this Miss Greenberg right here? Are you Miss... What's your name, ma'am?
That's Cannon, Your Honor.
Oh, Miss Cannon. Somebody put up your bond.
She bonded.
Don't
Okay.
go back. Ma'am, don't return to Mona's bar. Okay? You're not allowed to go
Okay,
back
that's cool. That's fine. Thanks.
Thank you, ma'am.
All right. Thank you.
What, are you Risa Greenberg?
Yes, sir.
Okay,
Yes.
ma'am. We have the attorney in the courtroom, Special Public Defender, Mr. Shate.
Fort Lauderdale is offered with order, counsel.
Okay. Ma'am, would you like to plead no contest today? The case will be over with. You leave jail today. That's the end of it.
Please, thank you.
All
Yes,
right, ma'am.
please.
You're not going to have a trial. You're not going to have your day in court. It's just over with today. The case is closed. Is that what you want to do?
Yes, please.
Do you need me to appoint an attorney to help you make this decision, or can you go without an attorney?
No. Fine, no contest. I done. Yes.
Do you need an
Done,
attorney?
please. No, sir.
Okay, how do you plead?
No contest.
I'll withhold adjudication, ma'am. Thank you.
Okay. All right,
Thank you.
Thank you. How about Gordon Koish? Mr. Koish, you're here for open container of alcohol. So, how would you, you want to just work this out today? I don't know. Did you hear anything, mister? You want to work this out?
Yes, sir.
You want to plead
Yes,
no
sir.
contest, case is over with, you're done, that's it?
Yes, I do.
Okay, do you need an attorney to help you make this decision? I have one here in the courtroom, or can you go without an
No,
attorney?
I do not. No, I do not.
How do you plead, sir?
No contest.
Withhold adjudication, good luck, thank you. Okay, I think that's it, am I correct?
I thought there was also Kimberly Baptiste and maybe a Dante Hoffman.
I think Baptiste, I already took care of that.
Okay.
I think that was an adjoining, like a misdemeanor and a MO, and it was all.
No, Baptiste was a recent.
Maybe I'm wrong, okay. Do you have it?
What matters is it's not really.
Where's
on the
Kimberly Is reset for what?
Tomorrow.
Yeah,
Tomorrow
it's-
afternoon. What was the other one you spoke of? Dante Kaufman?
Huh? Parlez-vous?
No paperwork, so that's probably going to be tomorrow.
Okay.
Okay? Do we have any other cases on second look? Okay, everyone,
No,
that's a
sir.
wrap. Thank you very much. We'll see everyone back here tomorrow morning.
One last day.
What about Roger McCreed?
Oh, Your Honor. Basically,
North Broward.
Got it.
you need to make a finding and set a bond on it. Is this Patrice, is this that case from this?
He already did. So I'll just set his bond at $1,000. Okay? Mr. On count 4, the warrant, I'm going to set your bond at $1,000. You're already being held on some big bonds anyway. Thank you. Thank you, Mr. McCreed.
Thank you, guys.
Yes, sir. All right, is that a wrap, everyone?
Yes, sir.
What do we do with Marvin Bush?
You just sent to division. That was the battery.
That's it.
And
See ya. Thank you, everyone. See you. Today's Thursday, right? Okay, what comes after Thursday? It's always the same day. Friday. We'll see you back here tomorrow morning, bright and early. Thank you.